to meet you again. Very welcome to all the participants today. I see some people from Argentina, from Germany. Thank you very much. I see some very good academics and scholars and people that are always following our activities. Thanks for that. Welcome to Daniel Rafecas, Javier Lopez Vizcayar, who are there in the audience, judges from Argentina. It is an honor for me to greet you and present our 5th Memoria Talk in the framework of the activities of our Memoria Legal Working Group of the Elizabeth Käsemann Foundation. This is a series of talks that we have started to do in our group as an opportunity to meet and open the group to the community and to discuss the most current issues of international criminal law and to share ideas and listen to different opinions. We always seek to learn and train ourselves in order to continue investigating the most serious human rights violations and international crimes in order to avoid impunity, of course, and also to advance in the tasks of memory and thus promote memory against forgetting. The foundation has different working groups and different activities with these objectives. We invite you to visit the webpage of the foundation where you can see what we do. And today we have the pleasure of talking with 4 leading academics who have been working on the issue of business and human rights, 2 experts from Argentina and 2 from Germany. Let me introduce you first to our first speaker, who is of our group, the introductory speaker, Stefanie Bock. She's PhD, Chair of Criminal Law, Criminal Procedure, International Criminal Law and Comparative Law at the Philipps-Universität, Marburg University in Germany, and Director of the International Research and Documentation Center War Crimes Trials. And then our moderator today will be Alejandro Checkman from our group too. He's PhD, Dean and Professor of Law at the Universidad Torquato Di Tella here in Argentina and Executive Director of the Latin American Society for International Law. So very welcome to everybody. And Steffi, I can leave the floor to you.
Thank you so much. And good evening, everyone, and a warm welcome from my side to our 5th Memoria Talk. When we talk about business and human rights, we enter a field where the pursuit of profit often collides with the protection of human dignity. Economic structures are not neutral. They can become criminogenic. That is, they create conditions in which systematic human rights violations are not just tolerated, but sometimes even built into the logic of profit maximization. From exploitative supply chains to environmental devastation or the financing of arms groups, we see again and again that copyright decision can have devastating consequences for individuals and communities alike. Yet our legal system, especially the German one, still tend to treat these outcomes as accidents or byproduct rather than potential crimes. If you look back in history, one moment that stands out as a turning point in confronting this problem is the IG Farben trial after World War II, one of the 12 subsequent Nuremberg trials. In this case, executors of the German chemical conglomerate IG Farben were prosecuted for their role in the Nazi war economy, for producing Zyklon B, for exploiting forced labor, and for profiting from the construction of the concentration camp at Auschwitz. The trial was, in many ways, the birth of an international criminal law of business. It recognized that corporate actors could contribute to mass atrocities not only by direct violence, but through production, logistics, and economic planning. However, the Nuremberg approach had a crucial limitation. It focused exclusively on individual criminal responsibility. The company itself, IG Farben, as a legal entity, was not on trial. This reflects an idea that was prominently expressed in the Nuremberg main trial. International crimes are committed by individuals, not by abstract entities. This individualistic focus has shaped international criminal law ever since, including the statute of the International Criminal Court. But this approach raises a deeper problem. Modern cooperation may be designed precisely to diffuse responsibility. Decision-making is fragmented. Accountability is distributed across department and global supply chains. In such system, we often face what Ulrich Beck once called an organized irresponsibility. Everyone is involved, but no one is truly responsible. So we must ask, is individual liability enough to capture the collective structural nature of corporate wrongdoing, or do we need to move beyond it towards a genuine corporate criminal responsibility under international law? This question has become highly topical again in recent years. A striking example is the Lafarge case in France. The cement company Lafarge is accused of having paid millions of euros to armed groups in Syria, including the so-called Islamic State, in order to keep its factory running during the civil war, and now faces charges concerning complicity in crimes against humanity. This case may become a milestone for redefining the boundaries between business activity and international criminal responsibility, showing that corporate conduct in conflict zones is not merely a matter of ethics or reputation, but potentially a matter of international criminal law. So as we revisit the legacy of Nuremberg, we might conclude that the challenge today is not simply to punish a few bad managers, but to develop legal frameworks capable of addressing the structural and collective dimension of corporate power, or to be more precise, the misuse of corporate power. Only then we can bridge the gap between business and human rights in a truly meaningful way. I'm very much looking forward to hearing the contributions from our distinguished expert and to the discussion that will follow. With that, I hand over to our moderator, Alexander.
Thank you so much, Stefanie. Thank you, Natalia. Thank you, everyone, for joining. It's a great pleasure to be moderating today's Memoria Talk. We have four wonderful speakers with exciting presentations. I'm going to introduce them one at a time. The idea is that they're going to speak for about 15 minutes, and then we will open it for questions. So if you have a question, just be prepared for the Q&A session, but also you can write them down in the chat box of the Zoom. So first, we have Alberto Barbuto. He has a PhD and a Master in Criminal Law from the University of Palermo here in Buenos Aires. He holds a law degree from the University of Buenos Aires, and he's currently the coordinator of the area of money laundering and terrorist financing in the Public Prosecutor's Office here in Argentina. The title of his presentation is Between Legislative Progress and Pending Challenges Towards an Effective Model of Corporate Criminal Liability in Argentina. Alberto, the floor is yours.
Thank you very much, Alejandro, Natalia, and to all the ones who has joined this panel. I would like to especially thank the Elizabeth Kaisman Foundation for this invitation. I'm very, very honored. I would like to present some ideas on the legislative progress and pending challenges aimed at
I think we lost Alberto.
This may happen. Let's see if he connects again.
Yeah, let's see if, okay, I think he's reconnecting now. We'll give him a couple more seconds, and otherwise we can move to Nadia's presentation and then eventually come back. Okay, yeah, let's move that way so we can use the time we have. So Our second speaker, now moving to the first slot, Nadia Bolodar. She's a lawyer and a political scientist. She's a lecturer in criminology at the University of Buenos Aires. She holds a master's degree in human rights from the Friedrich-Alexander Universität Erlangen at Nuremberg. And she's going to talk about prosecuting economic complicity, reflections on the case of Argentina's transitional justice process. Nadia, thank you for jumping in, and eventually we'll go back to Alberto when he returns. Thank you.
Of course. Thank you so much, Alejandro. So thank you so much to the Elizabeth Kesselman Foundation for this invitation, and especially to Natalia Barbero. This is a true honor to share this panel with my colleagues, and thank you all for joining. So may I share my screen first? Is it possible? Yes, right? Okay, let's try. I have to send a request. I'm doing that. I have a PPT for you prepared for today.
Yeah, David is telling us that should be done in a second.
It should be working.
Okay.
It should be working.
Okay.
Here we go.
Okay, great. Great. So you see the presentation there, right? Okay, great. So my work on this topic spans over a decade, beginning through the lens of genocide studies, and then from our research group, where around 2010 we began to conceptualize a model of corporate criminal responsibility for international crimes at the Faculty of Law at the University of Buenos Aires with Marcelo Ferreira, you may know him. And then in my master thesis, I conducted research on Argentine successful litigation strategies and legal mobilization from victims against economic actors. So my focus has always remained at the intersection of domestic and international criminal law and corporate conduct. But in the interest of time, I will move directly to the core question of my dissertation, which is about the Argentine transitional justice process and the prosecutions against economic complicity. So we will cover four main areas. First, the historical context of Argentina's transitional justice process regarding economic actors and their involvement in dismantling the working movement. Then the factors that enabled the initial suppression of transitional justice concerning economic actors. Then how about Argentina that became a global protagonist of human rights against economic actors, and finally the advances in transitional justice and its milestones. So as we have an international audience, let me begin by introducing you to what happened in terms of corporate complicity in core crimes, because we cannot simply talk about the domestic cases in Argentina without first understanding that they have the same historical pattern. While connected economic actors' participation with the state's criminal plan, it is also necessary to recognize the dismantling of the union mobilization and workers' activism as part of a social, economic, and political plan from the dictatorship. This is crucial for the litigation strategies of this kind, which I observed and analyzed in my master thesis. So we see that the state terrorism also brought economic, social, and labor changes. The initial focus of the transitional justice process on the armed and security forces role changed and expanded to include their collaboration with other power structures. Notably, we see here businesses and civilians from broad professions. This brought attention to the repression's impact on workers, trade unionists, and labor rights lawyers. So we see that currently there is extensive research that is documented this private sector complicity against their own workers. And we also see that this also entails cases of detained, disappeared businessmen. So we see in this case, if you want to check it out, there is the McIntyre case in Argentina. So we see that these were not isolated incidents, but rather systematic practices. So although companies and businessmen were identified early on by the Truth Commission and in the trial of the juntas, victims of corporate power encountered significant obstacles and delays in advancing judicial proceedings. I identified 5 factors silencing this, but of course, the list is not exhaustive. So first, we see that the accountability for human rights violations faces a dominant state-centrist conception in transitional justice and international human rights law, which is their legal paradigm. This paradigm and excessive trust in the justice pillar of transitional justice was decisive in the mode of knowledge production of what happened during the last dictatorship. This legalistic orientation emerged from basically from two elements. So first, the disproportionate influence of jurists over other social scientists, like economists, in shaping transitional justice mechanisms. And second, the strategic reliance on developing the Inter-American human rights jurisprudence. Although the Inter-American Court acknowledged responsibility on non-state violators during time, its state-centric enforcement necessarily was concentrated on state obligations and state actors. Then we see a second factor here, the inherent limitations of a persecution-focused approach. So we see that criminal law requiring proof beyond a reasonable doubt for specific acts struggles with different layers of culpability, such as passive acceptance, moral complicity, or having indirect benefits, wrongs that often fall short of criminal liability. Consequently, attention narrows to those who gave the orders or directly executed the crimes, leaving broader patterns of complicity unaddressed. Also, the inclusion of civil actors dismantled the long-held vertical repression model, which is described as the violence as flowing exclusively from the military command to an innocent civil society. So this basically exposed dense networks of complicity that redefined understandings of power distribution during the state terrorism. The third factor that I see here is, of course, as Stefanie addressed, that corporations lack criminal liability in Argentina as well. So as legal entities, they lack criminal liability under the ICC jurisdiction as well. So consequently, in international criminal law and Argentine criminal law, liability targets individuals, not legal entities. So the corporate liability applies narrowly to selected offenses related to corruption. Due to these procedural constraints, prosecutor efforts have basically targeted businessmen or CEOs, and their involvement was typically classified as complicidad in Spanish and the Argentine Criminal Code, or aiding and abetting for the international criminal system. And human rights violations were perpetrated mainly by the state forces. The fourth factor that I see is that civil and labor law cases were blocked by the statutes of limitations. Despite early civil and labor lawsuits during democratic restorations against corporate involvement, as we see in many cases, you see there the logos of Ford, Mercedes-Benz, and Veloz del Norte, because these were cases that were progressively blocked by the statutes of limitation. Moreover, the impunity laws severely restricted the judicial proceedings, while the presidential pardons definitely closed all the options for workers and their families. And the last factor that I see here is that this neoliberal economic narrative that really stands out today, of course, as well. And we see that from Argentina's democratic restoration until the 2001 economic crisis, the transitional justice process concerning corporate accountability was delayed by this narrative, which basically highlighted economic actors in the democratic transition as necessary and fundamental. So how did Argentina become a global protagonist in prosecuting economic actors? While the business and human rights soft law instruments represent notable advances, their implementation remains uneven across states, and victims lack effective remedies at the international sphere. despite the adoption of a binding treaty is essential to establish binding corporate human rights obligations, it doesn't currently exist. So the only way to go beyond corporate voluntarism is for domestic law to step in, either from the domestic courts where the abuses were committed, or from foreign courts where the corporation is established. Something that was fundamental for my research was that the corporate accountability database that was developed by Payne Pereira and Bernal Bermudez revealed that Argentina, from 2005, pioneers another dimension beyond military and security personnel. It has initiated more cases against economic actors for atrocity in a post-dictatorship scenario than any other country in the world over the last 20 years. Nevertheless, this judicial activity does not disprove the persistence of a global norm of corporate impunity. So despite this impunity persisted, in the middle of the 90s, there was a transformation in accountability narratives, and prosecutorial attention carefully shifted toward civilian accomplices. We had the truth trials in Argentina that provided new platforms for workers to recount their experiences of organization and repression. This was seen in both Mercedes and Ford cases. Internationally, we see the 1998 case of the CTA, the Argentina's Worker Central, because they appeared before Judge Baltasar Garzón to denounce a concerted plan between economic groups and the armed forces to discipline the working class, such as I explained before, to achieve higher profit rates and economic concentration. Likewise, efforts expanded to include cases like the 1999 lawsuit in Germany against Mercedes-Benz Argentina manager Juan Tassekraut. In 2005, the Supreme Court declared the impunity laws unconstitutional at the Simon case, as well as at the amnesties were declared null, allowing for the reopening of proceedings. So for the last 20 years, significant judicial cases emerged regarding the intricate relationship between the armed forces and corporate power. However, they saw a complex path of both progress and setbacks. So there are many cases to talk about, but we're going to focus only in the advances. In 2012, we were protagonists of the unprecedented criminal conviction of the Mendez brothers, two civilians who provided a farm to operate as a clandestine detention center and were found criminally liable in the enforced appearance of and murder, of labor lawyer Carlos Moreno. He was engaged in the legal representation of workers at the Loma Negra cement conglomerate. Notably, the Mendez brothers were acquitted in 2021, but now are being investigated in the La Huerta mega trial for the Loma Negra workers. We see a shift in this litigation since 2012. This is characterized by the extension of prosecutions to senior executives and businessmen of major national and transnational firms. Also, two main political developments that needs to be addressed. They emerged in this period. In 2015, we have the Civil and Commercial Code reform addressing the imprescriptibility of civil claims arising from crimes against humanity. We also had the New Truth Commission. I don't know if many of the Argentinians remember that. This New Truth Commission regarding economic actors was created in 2015. Despite this approval, the establishment of this New Truth Commission remains indefinitely delayed. In 2016, we have the Marcos Levin case. He was convicted, he was the Veloz del Norte owner. He was convicted for the unlawful deprivation of liberty and torture inflicted upon one union delegate. While not the first businessman, he was the first. This was a milestone in establishing his direct participation in the repressive apparatus deployed against his own workers. This case had all the characteristics of a businessman who contributes to eliminating workers and enforcing discipline by that. This ruling really created a positive precedent for future cases. Then in 2023, Levin was again convicted for crimes against humanity in a new trial for the remaining 16 workers that were also abducted and tortured. In 2018, a significant advance occurred in the 4 case, which convicted managers of the car plants as necessary participants in the human rights violations against their workers. And in 2021, we saw that the state acknowledged the institutional responsibility in the enforced appearance of the 4 employee Pedro Troiani, with recommendations from the Inter-American Commission and binding commitments to support victims' claims in civil and labor litigation. So to go for some conclusions, and I must end here. So in spite of these advances, many challenges remain. Some trials reach the oral stage, with accused from the armed and security forces without addressing the economic complicity. The existence of multiple obstacles in terms of collecting evidence, because the aiding and abetting from business people in these cases is really difficult to prove. And also there is the power of veto, the ability of corporations to frustrate, delay, and dilute judicial processes. So this power is not only exercised in a single act, but through a combination of strategic, legal, and political resources. So Argentina's transitional justice highlights the complexities and necessity of prosecuting economic complicity in human rights abuses, but also efforts from other transitional justice pillars remain. So these lessons provide guidance for advancing justice globally. Thank you very much for your attention.
Thank you very much, Nadia. So we have about a bit more than 11, 12 minutes for questions. You can raise your hands, or I think we are a sufficiently small crowd, so you can open your mics and ask directly. I can break the ice, but I wouldn't want to abuse my position as the chair.
Perhaps we might wish to discuss all inputs together at the end. This is an idea to see, to highlight some links between them. Okay, that's a good. And okay, so let's go back to Alberto. So let's hear from you, Alberto, for 15 minutes, and then we.
I'm very sorry for the connection interruption experience. Thank you for your patience. I was saying that in my master's studies, I investigated the responsibility of companies for great breaches of human rights. Later, in my doctoral research, I deepened my production taking a law, number 27401 in Argentina, passed in 2017 as a central input for analysis. As I will explain, both works present results that can be useful in this session, for which I was generously invited. So, let's talk a little bit about the foundations of my work. The master thesis addressed the dogmatic and political criminal foundations of the corporate criminal liability. It links and limits with Argentina. So this review had the purpose of bringing to light arguments to make viable a legal solution compatible with the text of the Argentine Constitution years before the sanction of Law 27401. One of the central points was to adequately justify the reasons that made it unsustainable from a constitutional state of law to continue maintaining an unequal space of responsibility between natural and legal persons, and why in a society like Argentina, the balance scheme had to be guaranteed from criminal law. There is a double layer of considerations here. On the one hand, The arguments that per se justify an advice, including legal entities as autonomous subjects of imputation, and on the other hand, including within the justifying reasons a general weakening of criminal mandates for natural persons as recipient subjects, fundamentally due to the irrationality of reacting with less intensity towards the actors who organize productive resources in a more intensive and extensive way. To the later, we could add the communicative differential that corporate culture has as a translator of state regulatory messages. The legal entities can present a much stronger heterodetermination. This is the determination based on the pressure exerted by another, which respect to the corporate culture. To resolve this, I have studied the evolution of imputation theories and highlighting the importance of specific corporate duties. For example, internal oversight duties that establish corporate guilt. Another axis was to compare was the comparative review of regulatory models in countries with developed economies. In this sense, it was explored the privilege of administrative solutions in systems such as German or Italian, the predominance of criminal solutions in the United Kingdom and the United States of America. In addition, an administrative solution that registered a metamorphosis toward the criminal option that appears to be successful, like the Spain case. All cases show relevant lessons, but if I have to summarize them, I would say that the most important variable is the game of compliance or the preventive dimension with a state that basically is delegating internal control under regulated self-regulation. Likewise, criminal prosecution agencies basically negotiate and avoid trials, or at least they show the state company association can show unexpected effectiveness if that synergy is polished and becomes a virtuous cooperation scheme. But this must be accompanied by an institutional communication strategy that shows the state as the articulator of an effective solution, banishing images and messages that could be confused with any type of complicity. Finally, the dangers of seeing later criminal system in administrative schemes only differentiated by labels and the general comparative ineffectiveness of systems that provide for this type of responsibility only in special laws and not in the general parts of the criminal codes. In this way, I would like to add that later in my doctoral thesis, I critically analyzed the law 27401, which introduced a criminal regime for a limited catalog of corruption crimes committed by legal entities. In that sense, this law marked a historic advance by breaking the legal taboo after the Argentine Supreme Court of Justice in case known as Fly Machine from 2006 that appeared to seal the discussion by appealing to traditional principles that deny the ability of ideal entities to commit crimes. It wasn't until 2024 that the first emblematic case of judicial application of the law occurred, with the application of an effective collaboration agreement. Very briefly, the case involved a private security company listed on the stock exchange of a Nordic country, which to obtain various public contracts would have paid bribes to officials from different departments and levels of the states in Argentina. This is important because it showed that the public prosecutor's office can take charge of these cases, the clear savings in time and effort with good use of internal investigations, as well as the multiplier effect of cases, since a case of Law 27401 generated several corruption investigations against public officials. Another focus was the mandatory integrity program of the law. In October 2000, 2018, the Public Ethics Secretariat issued a resolution with 70 pages of technical guidelines to help companies and authorities. It recommended that firms adopt code of ethics, confidential reporting channels, internal audits, due diligence on third parties, etc. My thesis emphasizes that these guidelines aim to prevent, detect, and remediate acts of corruption and assesses the challenges of implementing them in Argentina companies. In practice, many small and medium firms still lack of a compliance culture and enforcement controls are weak. Implementation has faced institutional hurdles. Federal criminal courts and prosecutors lack prior experience with corporate cases, and the judiciary is not specialized in compliance issues. Moreover, resources are scarce. Technical teams, forensic accountants, auditors to investigate complex corporate crimes. In general, the lack of corporate liability was flagged by multilateral bodies as a weakness. The law 27401 moves in the direction of the OECD guidelines and Gafi, FATF in English, called to combat bribery and money laundering. But my thesis concludes that much remains to be done. In conclusion, Argentina has achieved a balance of advances, but it still has critical gaps. Progress includes enacting the law, which I'm talking about. The first judicial application of the law in 2024 also sends a signal that authorities will require a compliance program to be effective. However, some gaps remain. The law covers only public sector corruption crimes, so many corporate crimes remain outside the criminal system. There is no consolidated case law, and resistance remains among the private sector and even parts of the judiciary. In retrospect, Argentina's 2017 corporate liability law falls short of international best practice. Its scope is narrow, covering only certain public corruption offenses, and it merely incentivizes compliance through optional integrity programs rather than mandating them. Critics note that some of its provisions even hinder effective application, dampening the intended company-government cooperation in investigations. Key authorities like the Supreme Courts and prosecutors' offices have yet to clarify the law's contours, at least as far as its associated practices are concerned. In practice, the limited offenses catalog and lack of decisive case law have constrained the law's real impact. These legal gaps are compounded by deeper structural deficit. Roughly, Argentina presents a high poverty index and a large informal sector persists. So many businesses lack of the resources or stability to build robust compliance systems. High labor taxes, public debt, and economic volatility further strain corporate budgets and deter investment in preventive measures. On the external front, Argentina's relatively protectionist trade environment limits exposure to global norms. And in Latin America, its corporate liability regime remains an outlier, basically for moving away from a trend where the design was based on a serious or relevant organizational deficit, like in Chile, for instance. Institutionally, the framework suffers from weak designs. There is no dedicated compliance authority and scarce resources for enforcement. Coordination among the federal government and 24 provincial systems is ad hoc, and no unified guidelines have been issued. Without clear institutional support and interjurisdictional cooperation, the law's effectiveness is undermined. A forward-looking reform agenda should broaden and deepen the corporate liability regime. First, the catalog of offenses could be expanded beyond deliberate corruption. For example, the law might cover certain reckless or negligent-based harms, serious environmental violations, labor safety breaches, or gender-based abuses, as well as crimes with serious human rights implications. Just to give an example for trafficking for sexual or labor exploitation, that current criminal corporate liability law omits. Second, the regime should be tailored to Argentina's economy, emphasizing compliance in strategic sectors so that corporate obligations align with industry-specific risk. In line with international models, strengthening mandatory internal controls in this area would bring legal obligations closer to the realities of national production matrix. Finally, as Argentina finalizes its shift to a accusatorial criminal procedure at federal courts and provincial levels, the corporate liability framework should be updated for consistency. Reforms could ensure that plea bargaining, evidence rules, and procedural rights for companies are coherent under the new criminal codes. These proposals, drawn from comparative best practices, would strengthen deterrence and align Argentina's corporate liability regime with global anti-corruption and compliance standards. The challenges are, in my view, of great importance, and the gap between regulations and practice too evident. Thank you very much for your attention and this opportunity. Thank you.
Thank you so much, Alberto. So now we can open the floor for questions for both Nadia and Alberto. We have about 20 minutes or so. Okay, I'm going to break the ice. And as I said, you can unmute yourselves, or you can send written questions through the chat box. So I have a question, my first question for Nadia. One of the elements that I think was crucial for the way in which the Argentine transitional justice movement developed, in the sense of Truth Commission, the juntas trials, and then the reopening of the investigations in the early 2000s and the truth trials that you mentioned, was the work of victims, the victims and victims organizations. In my work, I've seen that they were critical in drafting the sort of the scope of what CONADEP, the Truth Commission, was doing, and that led to much of the evidence that was used in the juntas trial. So my question is, to what extent were victims not as concerned with economic criminality as they were concerned with the other forms of criminality, particularly by the armed forces, and whether that influenced the way in which the Argentine transitional justice movement developed?
Thank you, Alejandro, for your question. Well, we see that the victim groups have addressed this economic complicity by the trial, the intended trials in civil and labor law that I mentioned. So we see an understanding from the victims that they were going to try to prosecute, whether they couldn't, of course, go by the criminal law proceedings. They were trying to do something in respect to the business involvement, not only regarding the state actors. Because in all the cases that we see, in these cases, the litigation was there from the very beginning of the transitional justice process. So I don't know if this was on purpose from their side, because they were, for example, we see that Pedro Troiani, who I mentioned, he was really involved in pointing out the responsibility of the managers of Ford in Pacheco. So they were really aware of the situation, and they tried to do their best, as I told you, from the civil and labor cases. But yeah, I mean, I think this was more like silenced, and at some point they were hidden, if you must say, because at some point when I started working on this from genocide studies perspective, their identity were like was at some they were silenced. They were no one talked about workers like 15 years ago. It was more a disappeared person, right? Not their identity. No, their union mobilization was not addressed, and it was crucial for them because you can analyze these cases directly through how they were attacked for being part of this working class. So I'm not sure this was something from the victims. I think it was more from how we addressed the transitional justice mechanisms.
Dorothy.
Thank you.
Yes, you
Can I
go ahead, please.
Thank you. Thank you very much for your very interesting speeches and presentations, both of you, Alberto and Nadia. I would like to ask if one of you could say something about the state of the proceedings against Mercedes-Benz.
Yes, of course, I can tell you something about that. So we have one victim, Hector Rato. He is the first. He's testified in the case against Juan Tasselkraut, and we are still waiting for the oral proceeding to begin. So yeah, it was reversed in appeal, and then when it went back to the first instance, so they said the trial must be done, and we are still waiting for the date to begin. So I can tell you, I don't know if someone else from Argentina can say something about that, but regarding the news, that's all I have to say, that we're waiting for the proceeding to begin.
Charlotte?
Yes, thank you so much. It's such an interesting perspective that you both shared. I was just wondering if I understood correctly that actually the cooperation from your perspective or from an Argentinian perspective is more of an aiding and abetting actor in a state crime, and or from a delaying tactics perspective that you talked about, Nadia, and or from this organizational deficit perspective that you talked about, Alberto. But what are you focusing on, for example, on this Mercedes-Benz case? Are you focusing on the factor of, like Steffi talked about, the profit maximization as a factor leading to murder and disappearance, or are you focusing on the cooperation as a helping hand in a state crime that you are putting at the heart of your investigations? I hope my question was clear.
Alberto, do you want to?
Yes, Charlotte, I will try to answer. The Mercedes-Benz case is related to an aiding and abetting of crimes against humanity from some representatives of the company. Nowadays, the law that enables the criminal liability is for corruption offenses since 2017 onwards. So we are discussing the model for its limitations. We have a very narrow set of corruption legal types, but what refers to the crimes against humanity investigations, it's related to the facilitation, because Mercedes-Benz aid and abet the criminal crimes committed by the military government of that time. So I think that we are discussing this in two different levels.
I may add something here. So yeah, what we see here is that the main perpetrator is the state. So following Roxin's power apparatus, you may see that the aiding and abetting is to the apparatus, the power apparatus. So this person, Juan Tasselkraut specifically, facilitated the information of the workers from the inside the company, from the plant. So the thing is that because of his position, of course, he knew about the workers, he knew where they lived, they provided lists. And this is something very common in all the litigation strategies that we see here. So as I told you, the pattern of complicity is that they provided the information, they provided cars, mobiles for the kidnappings. Even in the fourth plant, they constructed a concentration camp where the tortures were made. So yeah, we see that the civilians, because as Alberto addressed, we don't have a criminal liability for legal entities in Argentina. So the prosecutions are towards civilians. And these people, from their position, facilitated to the power apparatus to commit the crimes against the workers.
Thank you so much. May I add another question if nobody else has questions? Because I think it's very interesting. So does this mean that from an intentionality point of view, you are focusing on economic activity that is directly linked to murder, like in the IG Farben case, for example? We had prosecutions of economic actors, only individuals, which is maybe understandable in the historical context, but they were directly linked to the murder in a concentration camp. And so they had a very clear hierarchical line of proofs. What the prosecution didn't focus on is the purely so-called neutral economic aspects that I don't believe in, but that, for example, from the Dresdner Bank, which was lending money to Nazis and of course contributing to that, but was completely cut out of the center of the prosecution's attention. Is there a parallel? Because I would assume that the layers of difficulty for you in Argentina are huge, because you are on the one side really fighting the state piece that might be really challenging, and you needed the victims' parts to get to a certain point. But on the other hand, I wonder, is it easier in a way to prove the intentionality because it's very directly linked to the murders and the disappearance? And are you focusing only on that? I'm so sorry if I exhaust you with my questions. I find it very interesting.
I don't know if I can answer completely that question. Maybe it's more for Nadia than for me, but I think that we have different levels of effort. Historically, maybe we see here Dr. Daniel Rafek as a prominent judge in Argentina. We see from 84 onwards efforts increasingly trying to address more complex investigations. Prominent leaders first, middle, hierarchical offenders, And the discussion for corporate crime or crimes aided and abetted from corporations, it's differ for more recent years. So I think that this explained perfectly these efforts you were trying to address, Charlotte. And I think from the point of the criminal liability of the present, of today, we need to learn from that lessons and to make our catalog of crimes wider, because we have offenses and criminal human rights abuses that are not captured by the criminal liability law of 2017. So maybe we are missing the opportunity. We are the limited catalog of corruption offenses left a lot of things outside the big picture.
Nadia, you want to say something on this?
Yeah, perhaps so. So the point is that what you see in the strategies from the victims and from the private prosecutors in these cases, it's really important here to address the historical pattern, as I told you, because this is like, if you have a crimes against humanity, the context is provided by the historical and social discipline from the workers, from the businesses, from the managers to the workers. So this is really interesting that the strategies were really created through the leading experts, historians from the economy, political scientists that were brought to trial to explain the judges what was this, like this changes in the economic pattern in Argentina. Because what really stands out is that the working class in Argentina at that time was the most advanced in the region. So they were an obstacle for the political and the economic the disciplination that they needed. So when you link this intention of discipline workers in a specific context, you can like justify this connection between the crimes against humanity and the context that you see towards the attack to the civilian population. Does it make any sense, Charlotte?
Yes, perfectly. Thank you so much to both of you. Very, very interesting.
Okay, it's 3 p.m. sharp here in Buenos Aires, later in Germany and in continental Europe. We may move to our second batch of speakers, and perhaps we can leave any remaining questions for the final discussion. So we now move to our German-based group of wonderful speakers. We'll first hear from Ms. Canel, or Dr. Canel Lavitte. She's co-director of Business and Human Rights Program at the ECCHR Berlin. And the title of her presentation is Litigating Corporate Accountability in International Crimes, Lessons from the Lafarge Case. Canel, the floor is yours.
Yes, thank you very much. Thank you so much for inviting me to this conversation. I learned a lot from our colleagues from Argentina. It was a great conversation. So I hope that despite the late hour for those in the same side of the ocean than me, I will manage to keep also the attention and to also share some from my expertise and my knowledge. So ECCHR has been working in the field of corporate criminal accountability in the context of armed conflicts or repressive regimes for more than a decade. And I have to see that, unfortunately, while I do see that the field is progressing towards more accountability slowly, it's also clear that corporations still very much benefit from a lot of legal, but also social assumptions, both in law, in the interpretation, but also in society. And I'm going to try and explain this a bit more concretely. But I wanted to illustrate these main thoughts, that there are a lot of assumptions that still protect corporations from accountability and that feed their impunity, with two cases that ECCHR has been working on, and mainly the Lafarge case, which was already briefly mentioned, because I think that in particular the Lafarge case is deconstructing slowly but surely some of those obstacles that we've been witnessing for many years. Before I tell you about the Lafarge case, I just start with saying the most recent update on this case. Last week I was, and still I am actually in Paris, because the trial in Paris started on the charges of financing of a terrorist enterprise against Lafarge as a legal entity. And I will explain now a bit later that French criminal law allows for corporate legal entities to be charged for corporate crimes committed through their subsidiaries. But this trial really is against Lafarge as a legal entity, 4 of its former executives, both in France and in Syria, but it's really focused on the financing of a terrorist enterprise and violations of sanctions, which is obviously different from the other parts of this case that ECCHR, as well as former employees of Lafarge and our partner in France, Sherpa, stand for, which is the complicity in crimes against humanity. So I will just leave this away. I will not speak about the trial, but I will speak mainly about so far the case and the legal findings and what it tells of what corporate accountability means as challenges for us in terms of international crimes. So briefly about the facts. So Lafarge is a French company, giant cement multinational. Today, the world leader in cement making, and it is now has merged with a Swiss company called Holcim, but it doesn't matter for the case that is currently pending in France. And in 2007, Lafarge managed to secure the largest foreign investment in Syria outside of the oil sector by buying a massive cement factory in Halabia, which was located in northeast Syria. And it started operating this factory in 2010. The conflict in Syria started next year and very rapidly and dramatically escalated. Other multinationals like Total, Schneider Electric closed their activities because of the conflict. They took the decision to leave, but Lafarge took the decision to stay. And this meant 2 things mainly. One, the factory continued to operate in a violent, explosive context, and that meant that the local staff had to go through regular checkpoints that were held by different armed groups, including groups listed as terrorist entities like the Islamic State. Some of the local staff was kidnapped, some of them disappeared. And Lafarge decided in July 2012 to evacuate its international staff because of the danger. But according to the testimonies that have been included in the criminal complaint against Lafarge in France, and the workers that we've spoken to, the Syrian workers were forced to work by Lafarge, who was exerting pressure on them to come and work at all costs, even when they were expressing their fear of going through the checkpoints. That was the first consequence of Lafarge's decision to stay: risks for the lives of its employees, its Syrian employees. Second consequence is the one that I think it's most known in the public, is that Lafarge paid various armed groups, including the Islamic State and other groups, in order to secure the ability and movement of its trucks, its cement, but also its employees. And it also enabled Lafarge this financing to access raw materials that were essential for the production of cement. So it's only in 2014, in September, when the Islamic State actually took over the factory with surprise and violence. This is only when Lafarge closed the factory, which was then controlled by ISIS, and the former employees of Lafarge were left to flee on their own, privately, without any evacuation plan. So in 2016, in November, our partner organization in France called Sherpa and ECCHR, together with 11 former employees of Lafarge, filed a complaint against Lafarge, as well as several of its former executives, for complicity in war crimes, complicity in crimes against humanity, financing of a terrorist enterprise, endangerment of people's lives, being the lives of the workers, but also violations of international sanctions. And since then, the judicial inquiry has identified that these arrangements, the payments, of Lafarge to armed groups amounted to roughly 13 million euros. So I wanted to then dive a bit into the legal reasoning in this case, especially on the intent of complicity, because I think it really is a legal reasoning that shows a beginning of deconstruction of one of the arguments that corporate actors bring forward, and that is that they are neutral actors. They cannot be contributing to international crimes because their objective is to do business, which is a neutral objective, and therefore cannot be characterizing criminal intent for complicity or for any other mode of participation in crimes. The first element that I want to clarify is that under French law, companies, as I said, corporate entities can be criminally liable for offenses when these offenses are committed on their behalf by their organs and their representatives. And in this case, this is very clear because we could see in the judicial inquiry that the decisions to make payments to the armed groups were made by the Syrian subsidiary, but with the knowledge and the validation of headquarters corporate executives as well. With regards to the intent of complicity, so following a note that ECCHR and our partner sent to the investigative judges in France, Lafarge was charged in 2018 with complicity in crimes against humanity. And this was the first time, if I am not mistaken, worldwide, that a company as a legal entity was charged on these grounds. Complicity under French criminal law is defined as the knowingly facilitation or preparation of a crime. And Lafarge obviously appealed their indictment. And in November 2019, the investigative chamber of the Paris courts found, on the one hand, that there was sufficient evidence to claim that ISIS and other groups committed crimes against humanity in the vicinity of the cement factory in Syria when it was still operated by Lafarge. But at the same time, it considered that, it considered also that Lafarge could not ignore the commission of these crimes because they were too close and too documented to be ignored. But the Court of Appeals decided to overturn the charge of complicity in crimes against humanity because it found that the financing of those groups was not done with the intent of contributing to the crimes against humanity, but it was done with the intent of maintaining the factory running. The question, therefore, that we posed to the French Supreme Court was the following. Does the intent of an accomplice require a special intent, a dolus specialis, to have acted with the willingness, with the intent of associating themselves to the commission of the principal crime? The Supreme Court, in a very interesting ruling and historic, I would say, in September 2021, considered that, and I quote, knowingly paying several $1 million to an organization whose sole purpose was exclusively criminal is sufficient to constitute complicity, regardless of whether the party concerned was acting to pursue a commercial activity. It also went further to saying that it is sufficient that the accomplice has knowledge that a principal perpetrators are committing or are going to commit a crime against humanity, and that by their aid or assistance, they facilitate the preparation or the commission of the crime. So the Supreme Court really made a clear distinction between intention and motive, saying that it really doesn't matter, and here I quote again, that the accomplice acts with a view of pursuing a commercial activity, because that is a circumstance that relates to the motive and not to the intentional element. So this is really the milestone that we hope will get to court, because at this point, although the trial is just starting on financing of terrorist enterprise, there is still a judicial inquiry ongoing on the complicity in crimes against humanity. Another very important element that I think this Lafarge case has contributed to deconstruct is this the corporate veil, in the sense that mother companies, parent companies are arguing that they cannot know what has been done by their subsidiaries, and they cannot act on what is being done by their subsidiaries. And in this case, all the payments have been made from the subsidiaries' accounts in Syria. And here, the French appeals courts also made very interesting statements, and it found that because the mother company in Paris had full capitalistic control, or almost full, 99% of its subsidiary in Syria, but also that it had operational control over the subsidiary by very clear decision-making chains that went between the headquarters and the Syrian subsidiary. It found that the subsidiary had lost its autonomy because of the permanent immixtion or interferences of the parent company in its operational and capitalistic affairs. And that is how the payments and the criminal liability can be also attributed to the parent company in Syria, in France. I wanted to draw very clear, to make one remark on the Lafarge case quickly, and draw to open the conversation in just a few minutes, a parallel on the topic of arms exports and corporate criminal liability. One, on the Lafarge case, I want to say that this is a case that is exceptional in the sense that we got access to a lot of internal evidence through leaks that initially came from former Lafarge employees themselves and who were later investigated by investigative journalists. And those leaks basically show the internal discussions within Lafarge that are giving us the proof that the parent company was aware of what it was doing and was validating the decisions of the subsidiary. And this is exactly the evidence that most of the time is lacking in those cases. And that's also how corporations can maintain these assumptions that they did not know what was happening along their supply or their value chains. So yes, this case is exceptional, but I think one should also understand, but I think probably everyone on this panel is aware that the behavior of Lafarge is not isolated. It's only the fact that we managed to get this far because of the exceptional evidence that is exceptional. So in just a few minutes, I want to say that ECCHR, but other organizations in Europe have been working on the topic of corporate criminal liability and arms exports, in particular in the context of Yemen. So we've been filing a communication to the ICC, International Criminal Court, in 2019, arguing that arms traders from different countries in Europe who exports weapons, bombs, missiles, fighter jets to Saudi Arabia and the United Arab Emirates may be contributing to the commission of war crimes and crimes against humanity in Yemen. And we've been basing this again on the principle of complicity or aiding and abetting. We've also filed a complaint in France against French arms companies And here, drawing a parallel from Lafarge, there are two interesting things. One is that the Attorney General in the Lafarge case mentioned that had Lafarge been exporting or selling weapons, its intent would have been even clearer, because one could deduct from the lethal nature of weapons the mens rea, the intent, more easily than it is the case with the financing of armed groups, because money is fungible. And the second element that is a little bit more worrying for us is that in the Lafarge case, the Attorney General and the Supreme Court decision that I've just quoted earlier mentions that financing a group whose sole purpose is criminal might be characterizing complicity. And the issue in the arms cases projects is that countries might be also using their weapons, obviously for defense purposes. And one cannot argue that the UAE and the Arab Emirates or Yemen, the Yemeni government, are only having criminal purposes. So this might be an element or an interpretation of complicity under French law that we will have to navigate when we hopefully get to the stage of indictments on the complaints that we have filed under French criminal law. I leave it at this because I don't want to take too much time, but I'm happy to go into more details on also the arguments under the International Criminal Court on those arms trade cases or any question that you might have. Thank you for your attention.
Thank you so much, Canel. That was great. I'm sure there's going to be a lot of questions, but just let's wait for the final presentation of today. Dr. Charlotte Smith-Leonardi. She's chair of criminal law, criminal procedure, and interdisciplinary legal research at the Universidad Bielefeld. And the title of her presentation is "What can criminal law contribute to prevent human rights violations in connection with corporate activities?" Charlotte, the floor is yours.
Thank you so much, Alejandro, and thank you, everyone. Thank you for the invitation. It's a real treat to discuss this topic with you all. So the development that Canel outlined, in my opinion, matters beyond France. It challenges long-held assumptions about how responsibility works in transnational business settings, assumptions that many legal systems, including Germany's, have been reluctant to abandon. And this is where I'd like to bring Germany into the picture. For nearly 70 years, the idea of holding corporations criminally liable has been debated in German legal discourse, but it has never really taken root. We continue to focus on individual actors, as Steffi said, the CEO, the compliance officer, the board member. We ask who made which decision, when, and with what intent. And then we try to fit that into a framework of procedural law that seem to collapse when confronted to a higher degree of complexity. Because the reality is this: modern corporate structures don't work in a traditional hierarchical way anymore. Decisions are decentralized. Risk is managed collectively. Responsibilities are diffused across teams and jurisdictions. And the entire system is shaped by economic incentives, by structures that reward risk-taking and ambiguity, especially in legally gray zones. So we end up in a situation where it's nearly impossible to prove individual guilt, and yet the harm is real. Workers are exploited, atrocities, as we heard, are funded, human rights are violated. So here is a disconnect that we have to focus on. And I think it is also linked to the work that academia still has to do. Right now, there are still significant blind spots in our legal research. We simply don't have a sufficiently developed framework for dealing with the externalities of otherwise lawful business conduct, what we might call the collateral damage of economic activity. These harms may not be intentional. They may be quoted as neutral, but they are predictable byproducts of a system designed to maximize profit. These harms are not intentionally created by corporations to murder or to do some damage, but they become naturally societal costs, often borne by the most vulnerable communities. So as long as economic criminal law remains self-referential, focused mainly on targeting individual misconduct to keep markets functioning, we'll keep overlooking these broader structural risks. And we, meaning we, the criminal law, our community, we need to move beyond narrow assumptions. Corporate involvement in human rights violations isn't limited to, even though it has a place, and I completely agree with Kanel, but it's not only limited to arms exports or breaches of trade law. It's often embedded in everyday operations, in how supply chains are managed, how risk is outsourced, how silence is priced in. And at the same time, and this is a little bit of a disconnect, and I think it's important to really try to look at this ambivalence. At the same time, we shouldn't assume corporations act like criminal organizations. That implies intent where often there is only a systemic dysfunction. So if we're serious about using criminal law as a tool to protect human rights in a global economy, we have to expand our conceptual toolkit. Let me briefly highlight a few elements that I believe are essential. First, we need a dual approach to corporate accountability, one that addresses both harms that have already occurred and failures to prevent foreseeable harm. So we need an act and a harm-based approach. In other words, we can't just punish outcomes. We have to hold companies accountable for failing to act when the risks were clear. That's the last aspect, is the basic logic behind due diligence obligations like those found in Germany's Supply Chain Act called Lieferketten-Sorgfaltspflichtengesetz, the LKSG, that is now heavily criticized. However, unlike this Lieferketten-Sorgfaltspflichtengesetz, which pairs vague best offered duties with severe revenue-based fines, a more effective model would rest, from my point of view, on clearly defined responsibilities and enforceable normative expectations. In this context, we also, from my point of view, need to revisit the burden of proof in high-risk sectors. For example, in areas like conflict minerals or forced labor. There, it might be appropriate to expect companies to actively demonstrate that they took adequate steps to avoid harm. This isn't about reversing the presumption of innocence. It's about responding to contexts where informational asymmetry is extreme and harm is systemic. For example, where it concerns cotton production in Xinjiang. There's simply no gray area anymore from my point of view. Second, we should adopt what some have called a smart mix of legal instruments. Criminal law isn't always the right tool, but it should be available when the facts demand it. Alongside it, we need civil liability, administrative penalties, and restorative mechanisms that allow victims a voice in the process. Lastly, let me turn to a third point: how we attribute responsibility. Corporate crime isn't one-dimensional. Just because a group of people works under the same roof doesn't mean there is a criminogenic corporate culture, like Schünemann, for example, expected. But there are cases where companies develop internal norms or incentive structures that effectively leave employees with no lawful room to act. And in those cases, holding the company itself responsible isn't just legitimate, it's necessary. This, I think, is where economic criminal law can make a real contribution, not by chasing individuals at all costs,
but by clarifying where responsibility lies, by drawing the line between personal fault and institutional failure. Sometimes that line leads us straight to the company itself. That said, we shouldn't give up on individual sanctions entirely, of course. They're still essential to deterrence. So we do need to take a hard look at the growing reliance on D&O insurances. If individual risks is fully outsourced, the deterrent effect of criminal law is undermined. And we should also consider new institutional models, especially for cases involving core international crimes. This wouldn't have to be criminal law in the traditional sense. It could take the form of a parallel procedure led by specialized chambers targeting corporations directly. Such a format could allow for more flexible procedures, targeted sanctions, a defined role for human rights organizations, and, importantly, proper attention to reparations for victims. Regarding the legal framework, and I think that's a question that we have all in common, I personally advocate for a nation-state-based approach to addressing macro-level corporate crime. Not because I believe that an international regime wouldn't make sense. In fact, it would likely be far more effective. But because ever since the Malabo Protocol, it has become increasingly clear that the political prospects for such a regime are dim. And not least because the ICC is currently forced to defend its core mandate against authoritarian pushback. So in my view, expanding the ICC's jurisdiction now on corporations would seem strategically unwise. This leaves national legal systems with the responsibility to take the lead rather than wait indefinitely for international consensus. I'm not sure, but I think my time is almost up, so let me end with this. The Lafarge case is a crack in what once seemed like solid concrete, pun intended. Whether the French courts ultimately convict Lafarge is, in a sense, less important than the fact that they are willing to try. That in itself is a signal and perhaps even a turning point. But we should be careful not to confuse accountability with moral closure. It's easy in hindsight to position ourselves on the right side of history, to say, of course, those companies should have known better. Those are the bad apples and the bad actors. Because the truth is, the truth from my point of view, I should say, the international economic system, our system, permits and in some ways encourages the pursuit of profit in fragile and violent contexts. Arms exports, critical raw materials, energy supply chains, all of these intersect with conflict, repression, and displacement. Lafarge is not an outlier, it's a mirror. So the challenge is not only legal, it's a political, structural, and yes, moral. And criminal law, while powerful, is just one part of the response. But it is a part that, in Germany, we should no longer ignore. Thank you.
Thank you so much, Charlotte. That was very, very sharp in terms of timing. So we have about half an hour now for questions. So please raise your hand, open your mics. You know the drill. Daniel, Judge Rafecas, whatever works best.
Thank you. Thank you, Alejandro. A question for Charlotte. Good afternoon from Buenos Aires. What is your opinion, Charlotte, about this influence of the Anglo-Saxon world making some kind of pressure in our countries in order to recognize some kind of directly criminal prosecutions of corporations? What do you think about that path? Is it you see as something that we must implement in our countries, or we must remain in an administrative way to put on trial on corporations, like you said?
So the US-American approach in general, not to put pressure on South America at the moment. You mean in general?
Well, we do have some pressure of some multilateral organizations and United States, and we must change our criminal code in that way, including the criminalization of corporation, for example, in international breaks.
Yeah, thank you so much. I am a little bit reluctant to find positive aspects in this bully strategy of the actual administration. So I will make like a broader point. I think pressure works in big corporation like how do you say börsennotiert, like DAX corporations, and we saw that in Germany, and maybe other participants are better suited to answer. We saw that in Germany, that it was a really turning point towards Siemens. The first pressure that was applied, and then towards Volkswagen during Dieselgate. And a certain amount of pressure from a deterrence point of view seems to have an effect on the big corporations to implement the cost of this so-called neutral business into their operations. It's a slower reactive mode. It's not the same as a human that understands. It's a slower reactive mode, but it seems to have an effect. But from my point of view, an approach like that, even though it might be efficient for some big actors, has a very important downside, which means you will, with an abstract law, have an effect on all companies. And the system is, of course, not capable to absorb all these cases. So the reflex of procedural systems is oft a form of negotiation, as you can see in the US-American system. So if you think about, okay, you have this huge pressure in form of a huge fine, and the situation, the procedural situation that comes after the negotiation, then you will have, of course, with the big corporations, with the best law firms, and a lot of impact also on society, like the wages they pay and the taxes they could possibly pay, and also the collapse of the economic structure if they are fined this high. That will lead to a negotiation situation in which they have a much better position. But if you have a medium or even smaller company that is targeted by the same strategy of dealing with corporate crimes, they will more likely be just hit by the sanction. Maybe they can open themselves in internal investigations, but they will more likely be forced by the prosecution to just admit, take the sanction, lose the jobs. And I think that's a collateral damage or an inequality that we have to take into account if we are organizing our criminal response in general. But that said, I think much more pressure to the biggest players is adequate if we find a way to target them in the first priority. I hope this answers your question.
Kanel, do you want to intervene on this?
No, that's fine. I think he was very comprehensive.
Okay. Boris?
Yes, thank you so much. Very happy with the group of speakers we have assembled. Thank you so much for your inputs. I have also several questions, perhaps starting with a question to the Argentinian speaker, so to speak. I wasn't clear about how the instruments that you were mentioning, both the case law that has been developed with regard to the dictatorial crimes, but also with the this corporate criminal or corporate crimes law that has been mentioned by Alberto. How can particularly this case law be brought back to present cases or actual cases? Are there any developments that are taking place to use this case law for present cases? This is the first question, and then to Kanel. My question is, how important in your evaluation is the fact that the French law provides for corporate criminal responsibility, also particularly with deconstructing this narrative of doing business is neutral? How important is this element for the broader change of ideas that you are trying to integrate into the general narrative on what companies are doing in these contexts? And to Charlotte, my question is, if I understood you correctly, your broader vision is a different kind of corporate criminal law than the one that might be in the making also in Germany at long last. And my question is, if I understood you correctly, that you are not intending a corporate criminal law that then just transfers the I don't know, failure of duties of individuals to the company. Would that be a corporate criminal law particularly for business actors, or do we have to then bring it back also to other forms of organizations? And how would that fit with holding states responsible? Just to understand this very fascinating idea that you proposed. Thank you.
Okay, Nadia, do you want to start?
Yeah, of course. Okay. Yeah, Boris, so if I got your question right, you were asking whether these cases were applied, like the concept of these cases were applied to current trials, right?
Yes, basically, if this case law has been used, or if there are plans to make use of it for actual cases.
Yeah. So we see an involvement of these cases. These are cases that are happening right now. So we are seeing like advances and setbacks in the case law, like in many regions of the country. So we are having, like, I cannot tell you like the amounts of cases that we have. There are lots of them and currently ongoing. So for example, last week we have the case of Asindar. I don't know if my Argentine colleagues take I looked to it, but yeah, it's really important because this case was like the laboratory for what came afterwards in the dictatorship in the whole country for all the regions. So what happened last week was that 2 executives and the policemen that were accused in the case were acquitted. And of course, the victims are going on the appeal path. So we see that the cases are moving. So you cannot attach the advances of the cases only to the political situation and to the political climate. So this is really interesting because, as I told you, the first case that we saw of a businessman convicted was during Macri's administration. So maybe you would say, no, this is not going to work. But actually, we saw the 4 case as well in the Macri's administration. So you see that the judicial sphere is at some point independent from the rest of the cases. But it's really fascinating because for example, I presented my thesis and then I was like, okay, let's cut it here because the cases are really moving. So it's really fascinating to me to watch how this develops. So this is something that it's going on right now. So if you watch the movie, the news and then the movies, because you see many things relating to in YouTube relating to these cases. You can watch, for example, the Ford case. I'm going to share it because I don't remember the name of the movie. But you see that the victims are really moving the cases, and they are fundamental for these judicial proceedings.
Thank you. Kanel?
Yes, thank you for the question, Boris. I think it's key, the fact that we have the corporate criminal liability possible under French law. I think it's key. I mean, for which reason? I think obviously because this is, in my view, the most strategic way to make sure that, or to ensure that there's going to be a change of commercial practices on the longer term. Because obviously this is what we see in every case, right? Corporate entities are going to blame the bad apples, as Charlotte was saying. I mean, this has happened in the Lafarge case pretty concretely. Lafarge has also sued some of its corporate executives. But also, I think, you know, if you look at the liabilities of each corporate executive individually, it's quite clear that all of them, their reasoning is led by the main objective of making profit, ensuring that Lafarge continues to make profits. The email exchanges, they show that all the corporate executives are talking about a cake, being the production of cement, and they need to have their part of the cake, and this is why they need to pay those terrorist groups. So that is really the revelation of the real motive and the problem, I think, in the way corporate actors are acting now and also in the global economic order, because there is no balance between this objective to make profits and also the need for embedding this profit in the respect of human rights and in sustainable activity. But if we only had the liability of the individuals, I'm not sure. So I'm not sure that because the problem is that the corporate executives and the headquarters, they have, in a way, the decision power, but they don't have the knowledge, the technical and local knowledge to make an informed decision, which is why very often in these cases, and it happened in the Lafarge case, they explain in the headquarters that they were expecting the managers of the local subsidiary to make the decisions because they had the expertise. And the subsidiaries managers are going to explain that they had the knowledge, but they had no no decision-making power. And this is how you create this circle of impunity. But because under French law, we have this possibility of holding Lafarge accountable, we are able to go beyond those defenses that all individuals might have individually, and to really bring back to Lafarge as a legal entity that it was mobilizing all its financial and global powers to ensure that it would maintain its investment, and it did so through its individual executives. And there's actually, for those who are interested, a very telling excerpt or passage in the court order, the order that referred Lafarge to court, that said, in this case, there is attribution to the legal entity because it's very clear that all the actions were done for the purpose of protecting the investment of the group. But that being said, even in cases where there is no corporate liability in the law, there is obviously ways of creating a narrative around the case that really shows how those structures, those corporate structures, are problematic and how they should be different in order to enable those who might want to make the right decision but cannot because they don't have the decision making, or the other way around, those who cannot make the decision because there's not the structure for them to get the proper expertise when they need it.
Thank you. Charlotte?
Yes, thank you. So first to the question, do I mean business actors? And the answer is yes. I think that possibly we could expand that to organizations that are also driven by profit maximization. And it might be like we live in a time where open corruption has a new meaning, so it might morph into something else. But first of all, I target business actors, corporate actors as a new form of addressee of criminal law that is different from organizations or states that are much more hierarchical, like Nadia explained as well. You have another chain of command, and you have another security to obtain what you want if you are potentially in a military context. So I find it even from a criminological and sociological point of view, I find it very interesting to really focus on the piece of profit maximization as a criminogenic parameter that drives the corporate actor. And I think we haven't addressed enough this aspect in the phenomenologic side of the problem, in the analysis side of the problem. That said, on the normative and also political side of the problem, I suggest that we should elaborate a system sui generis that I call a para-criminal system. And I propose that because I think this will address serious corporate criminality in a way that is tailored to the nature of the corporate agent. So my hope would be that a para-criminal system would be empowered to seriously address corporations as bearers of rights and duties. It's not, I often feel compelled to say, I don't want to abolish capitalism. Not all corporations are bad. Nobody says that. But so corporations as bearers of rights and duties that are not citizens in the same way as humans are. This has been a massive problems, and I would expand on the 14th Amendment that was actually tailored to Black African-American citizens that then have been used by corporations. So as a bearer of rights and duties that is not a citizens like we are, corporations who are fundamentally different from humans. And so have to be held criminally responsible in a serious matter in a court that is separate. So the piece of the harm is the same. It's a murder. We should call it corporate murder if it is one. We should communicate in a way not to speak about accidents and failures to comply. It might be a murder. It has, and I strongly agree with Alberto. We have to expand our perspective. Economic crimes it's not just corruptions. It's not just arms deals, but also administered to an actor that is fundamentally different, that has not the same ability to respond to a normative appel as, for example, Roxine would conceive it. So maybe the metaphor that works, and I say that in quotes, would be a new form of military court. So like in a military court, we talk about criminal law, we talk about criminal offenses, but they are administered in a procedural context that takes into account the specific nature of the addressee, which might be the military personnel because he is representative of a state, so he has to do things differently or has different responsibilities and so on and so forth. And the parallel part is we talk also about criminal law. Those are real criminal violations, but the actor, the corporate actor, is different in his capacity, But this doesn't mean he's not to be held accountable for serious crimes that we should label as such. That would be the idea.
Thank you so much. We have another 9 minutes, so any additional questions? Before that, let me note that Nadia has been kind enough to share some of the links regarding the cases she was and the movies or TV emissions that she was mentioning that are posted in the chat. So please feel free to take a look. Now for questions, I do have a question, but again, I don't want to abuse my position as a moderator here. Okay, I'll abuse it. So I find it very interesting, the whole Lafarge case saga. I wonder whether you can identify what you think has been different in this case. So why now? Why with this company? Why with this context? What's the driving force that has made it possible to change the central dynamic that has been kind of at the core of this session? And this is for of course, Canel and Charlotte, whoever wants to address it.
Should I start, Charlotte?
Yeah, maybe, and I jump in. Yeah, great.
Okay. Yes. I mean, one element that I've mentioned in my talk was the amount of evidence that I really believe is so exceptional that it explains not everything, but it explains that this case was able to move forward, because most of the time this evidence is with the companies who refuse to hand it over. Obviously, another thing is that under French criminal law, civil parties, so victims, can be also we as NGOs can be a civil party, because we can prove that there is a violation, we have a damage to our mandate, which is to accompany those affected by international crimes to seek justice. And as a civil party in France, and I think this is quite exceptional, let's just take Germany, the role of civil parties in France is very active. So we have the possibility to look into the judicial inquiry. We have the possibility to submit observations, as many as we want. We have the possibility to be heard by the investigative judges. We can also make proposals, which are only proposals, of course, but of witnesses or expert witnesses to be heard. And this is really something that we have used a lot. And we could see that it was followed by the judges because they did call for witnesses that we had recommended, for instance. And another important element, I would say, is the resources that are available in the investigative unit that is specialized on crimes against humanity and war crimes. I'm not going to say they have a lot of resources, but they have a specific expertise on these topics, and they have resources, for instance, to look at financial records, which I've heard from prosecutors in other countries that was a difficulty when those financial records become very opaque and very complex to understand. So yeah, I would say those three reasons: no, the amount of evidence, the role of civil parties in France, that is key, and also the capacitation of the investigative judges.
Yeah, I would second that. And as you're obviously very modest, Canel, I would underline the fact that the human rights organizations as ECCHR are doing tremendous work. And Nadia spoke to the fact that delaying tactics and resources are, of course, at the center of what you call impunidad and non-prosecution. So the fact that it is balanced by human rights organizations, or in Germany, Boris works with the Gesellschaft für Freiheitsrechte, so strategic procedural actions, I think now come into fruition. We really see the fact that they are well organized, extremely competent, and efficient in a way that they were not before. So they're really able to move the needle also in a time and context where resources in the courts are a serious problem. So prosecution is really limited by that. And so I would like close with actually a plea for using those resources, human rights organizations and third parties like that. And at the moment, and please correct me if I'm wrong, my interpretation is that they are interpreted as a threat instead of using their potential to really move the prosecution, talking to parties, looking for evidence, and really moving the facts. It doesn't mean that they are always on the right side of history, but we should acknowledge their potential and find a place in procedures. This also is a reason why I'm speaking for a para-criminal system, because you could be able to implement an actor like that. And I really applaud your work, as actually foundations like this one is doing, in really moving topics and for the better.
Thank you so much. So let us join me in thanking our four wonderful speakers, Alberto, Nadia, Canel, and Charlotte, for a wonderful, wonderful session. Thank you everyone for joining, and let's see you hopefully in the next Memoria Talk. Thank you.